We follow up now on the conversation with constitutional expert advocate Michael Osborne to take a look at the debate in Parliament earlier today, what it means for South Africa's state as a constitutional democracy. A very good evening to you, and thank you so much for speaking to us, Advocate Osborne. I'd like to start with that excerpt that we've just come out of the interview with the national chairperson of the ANC. Earlier on, you had the EFF leader, Julius Malema, saying that the ANC intimidated its members in Parliament from voting for the adoption of Section 89 on the report. But I'm just wondering, the ANC itself has its own constitution. Abiding by that, is that not, is that betraying the country's constitution?
Good evening to you. The rule generally is that a political party is entitled to conduct its internal affairs in terms of its own party constitution with a fair degree of autonomy. And if the proper process is followed and the members of the ANC who voted against the whip's instructions are given a proper opportunity to have their say, and all of the right procedural protections are afforded, I would think that it would be quite difficult for them to go to court and claim that they had a right to not to be disciplined by the party where they have failed to obey the whip's instructions.
Now, the EFF leader also threatening court action after what we saw in the National Assembly earlier on, saying that he is going to take this whole decision to the courts to challenge it. What avenues are there to pursue?
Well, in principle, the EFF or any other political party or any individual who's unhappy could approach the court, may well be able to approach the Constitutional Court directly, and they could seek to set aside Parliament's decision on the basis that it was irrational. Now, under the Constitution, all organs of state, including Parliament, have to act in a manner that is rational and consistent with the Constitution. I would think that, given the present perspective, the EFF or any other challenging party would face quite a difficult chance. They'd face significant hurdles in getting any court to overturn today's decision. And the reason is this. The Constitutional Court in 2018 made a determination with respect to an attempt to impeach Mr. Zuma. This had to do with his failure to implement the recommendations of the public prosecutor at the time. Now, the Constitutional Court took a lot of trouble to explore the meaning of Section 89 and its role in the overall constitutional structure. And what it held is that the burden of anyone seeking to invoke Section 89 is a very high one. And that's because the Constitution, Section 89 says the following: the National Assembly may, not must, but may impeach a president if the president is found to have done one of three things: involved himself or herself in serious misconduct, have breached the law, or be unfit realistically for medical reasons to stay in office. Now, that's difficult. It's not just that the president should have violated law. It must be a serious violation. And what a court will always do is they will say, of course, Parliament is subject to the law, and of course, Parliament must properly consider an application or a motion to impeach. However, because of the separation of powers, Parliament has a broad political power to make an assessment. And if you have a situation where one party has more than 50% of the members of Parliament, and that political party has made a determination not to vote for impeachment, it is extremely difficult, and I would think probably impossible, to persuade a court to overturn that.
All right. Thank you so much for speaking to us. Really appreciate you fleshing out some of those complex issues, just speaking to us about our constitutional democracy advocate, Michael Osborne.